Welcome to the House Judiciary Committee this Thursday morning, May 21st. And we're back to S-193. We did have a brief walkthrough of the amendment from the Committee on Appropriations. And we're going to hear a little bit more about the amendment. And I guess I had a question but I'll turn it over to you if you could just kind of generally explain the purpose of this amendment.
Yeah, when
Identify yourself for the record, I call.
Representative Trevor Squirrel with House Appropriations. When we heard 193 in our committee, as we were working our way through that and the bits and pieces that are there, we felt, based on past experience working with departments and agencies, that when we have studies being put together and which lead to development of something like forensic facility, that we certainly want a feasibility plan and those elements to go forward, but before the agency and any of its departments take any further action in terms of contracts, rendering to consultants or whatever, that feasibility plan needs to obviously be evaluated by commission jurisdiction, and that some action should be taken by the legislature before the agency moves forward with the actual facility itself. Obviously, anything that's contemplated in the feasibility plan is okay. I mean, it's contemplated, but that's fine. We just don't want anything to move forward with the facility itself in terms of commitment of resources, basically money. Because we've had experiences where departments and agencies come back and after the fact say, oh, we entered this contract with a consultant to do X, Y, and Z. We need $500,000. We're putting guardrails around that particular piece of the process.
So the question I had is that, so the feasibility plan, one of the items is looking at this item number 12, and I'm looking at draft number 7.1, page 26, that they can look at a competency restoration program within a Vermont correctional facility provided by an entity that is not under contract with the Department of Corrections. That doesn't seem to, so does this requirement prevent Department of Corrections from providing treatments in the interim under that section?
No.
Because that was kind of a question. It sounds like it's really the forensic facility we're talking.
Facility, any programming, it was
facility.
Yeah, that's correct.
You to confirm that was the understanding. Are there other questions for Trevor? All right, not seeing any. I would take a motion to find this particular amendment favorable. Is there a second?
Second.
And any discussion? Not seeing any, so all those who are in favor of finding the appropriations amendment favorable, raise your hand or say it. Coach?
Yes.
Yes, you said yes, and those finding it unfavorable, raise your hand. It's like that one was unanimous. Did I miss anybody except Alicia's not here? Did you raise your hand?
I didn't hear any. I didn't vote on it.
Okay, so I'll consider you absent on that. So 902. All right, thank you, Trevor.
Thank you.
Thanks.
Thanks, Trevor.
It's at the end of it.
All right, and so.
Hey. Thank you. Have a good day.
You too. Thanks. So if we could draft 3.1 of the other amendment made, if you could pass that out for us as well.
We have baked goods if you'd like to take one with you.
Oh, thank you. We have a bevy of baked goods upstairs as well.
Time of year.
Thank you.
I think so, yeah.
Okay. Just keep me posted. Yeah.
Thank you.
That's gonna just happen to print out.
Okay.
It's already set.
Thank you. All right, so this is something we looked at the other day. It is now on the calendar, on notice calendar. And it's amendment from members of the Human Services Committee, Representative Wood, Bishop, Cole, Estes, Garofano, McGuire, McGill, Noyes,
And Donahue,
and Donahue, I guess, okay.
they're real good.
Well, in fact, I haven't had a chance to say hello. I'm sorry I missed you the other day when you were here. So nice, it's so nice to see you in here again, so. But yeah, so we did take some testimony. We had a walkthrough by Eric, but we want to hear from the sponsor, kind of the why behind this amendment, as opposed to the what we kind of heard yesterday. So thank you for being here, Chair Wood.
Thank you. Thank you. Teresa Wood from House Human Services. Does it want-
No, the chair.
Okay. First, good morning, everyone. And thank you all for the incredibly hard work that you've done on this bill. And I know it's been, you've been through a lot of testimony on the bill, and our committee has taken quite a lot of testimony on the bill, although we haven't had possession of the bill. And I think you all know that, corrections and institutions and House Healthcare, House Human Services, and your committee have all been working on this bill. The amendment that you have before you really focuses primarily on language that acknowledges that a person with a disability may commit a crime, but that the disability is not the cause of the crime. That's it in the simplest terms. So it doesn't really change anything in terms of who would be eligible for this facility. It doesn't change anything in terms of what the services would be if they are in fact ordered to be in the facility. And so that's the crux of the main part of this amendment. The other thing that we focused on just to give you a little bit of background, I know you've had some information about Act 248. Act 248 has been on statute for about 40 years. It is a statute that has worked very well. It's a community safety and rehabilitation statute, sort of all wrapped up into one for people with intellectual and developmental disabilities. And those individuals who have been accused of a crime have been served in the community and have been served in the community very well. And that does include a case or two of individuals who have been accused of a crime that had a life sentence one of the qualifying conditions here. Anyway, the qualifying situation. So we came about this with probably a little bit of a different, when I say we, our whole committee, came about this with a little bit of a different take than in some places, because we have seen successful community-based programs for people to both respect the safety and ensure the safety of the community, provided by developmental disability service agencies, many of whom are designated agencies, some specialized service agencies, and who have been people who have presented a danger to the community. And so based upon that, I can say that we, have reluctantly agreed to the provisions of this bill that enable a person with that circumstance to be ordered to a forensic facility. But the bill also provides avenues for that person to be able to exit to community-based services. Essentially, there's many of the provisions of Act 248 are incorporated into this bill, as you know. And so those are things that I think strengthen the bill, and I appreciate the work that you all did to do that. A couple of the things that I wanted to highlight for you, in addition to sort of that separation of the person, what the act that they did from their disability, is that we wanted to ensure that a qualified evaluator was the individual with experience in evaluating people with different types of disabilities. So when we were talking about in the bill, you talk about the risk assessment. We wanted to ensure that it was a qualified evaluator based upon the disability of the individual. It is certainly, I'm sure you know in this committee that a person with a mental health diagnosis and a person with a developmental disability or brain injury or dementia, it is not the same individual who would be evaluating those folks. And there are, for instance, as I said, we have 40 years of experience in this field. There are risk assessments specifically for people with developmental disabilities who pose a public safety risk. So we added language about qualified evaluator. And then the other thing that, this was something that seemed to be over the top to me, for a facility that's going to be relatively small, and the need to have the presence of a 24 hours a day, 7 days a week medical staff on site. That seemed to be excessive and seemed to be something that would actually ramp up the cost on such a facility. And so we inserted as clinically necessary for the individuals who would be residing there. So that is the essence of this amendment. And as I said, Representative Donahue has asked to be on the amendment. Ledge Council is adding her to the amendment, and it should be posted relatively shortly for the full body to view. And happy to answer any questions.
Questions?
Or, go ahead. No, he had his hand up first.
Okay, Zach and Tom.
Thanks for coming in, Teresa. Appreciate making the time. I just have a few questions. I think the first one is on the topic of sponsors. I noticed that 2 members of your committee are missing. And I'm wondering if everyone had the opportunity to co-sponsor, or
Yes, they did.
and those 2 individuals elected not to.
They didn't respond.
So will you be checking with them to see if they want to be added when Rep. Donahue's name is added?
I certainly can. Yeah.
I just think it's conspicuous. It just seems strange that
It's not being offered by the committee. It's only being offered by members of the committee.
But all the names are members of your committee, right?
Yes, we couldn't offer it as a committee because we didn't have possession of the bill.
I understand.
Yeah.
But I just noticed that 2 names were missing, so I just wasn't sure if they were left off or they didn't respond or whatever the circumstances might be.
Well, I can be precise about the circumstances. We have one member who does not come to committee anymore, hasn't for several months now, and doesn't view it as that person's responsibility to come to committee. So when we discuss amendments, we discuss them in committee. We took hours of testimony in committee. It's that member's responsibility to be in committee. It's frankly not my responsibility to go try to track them
I don't
down.
disagree with you.
Yeah.
I don't disagree. I mean, I'm in this seat for that very.
Exactly.
Yeah. I mean,
Yeah.
You have to show up and do the work.
Yeah.
I totally appreciate that. It just struck me as odd. It just seemed like the entire committee was there, and I figured there was a reason behind it. And so seems like that.
Not
the
being
reason.
present.
Yeah.
Yes.
Non-attendance is,
Yes.
attendance is the reason there. The second thing, and I think this is maybe a topic of discussion that I'll bring up, when we talk about actually voting on this amendment, but I think there are members of this committee that are a little bit discouraged that this amendment is being offered after the consideration, after the committee took a vote, and before it even came to the House, before S-193 even came to the House floor, and then we have 2 additional instances of amendment. The appropriations I completely understand, because I actually had dinner with members of the committee last night, and we talked through any concerns that I had, and those were relayed. We haven't had that opportunity. But I'm curious why it's being offered now, prior to the bill coming to the floor, and it wasn't offered when the recommendations were included. I think it was in version 5.1 of the bill.
So I actually have been working with the chair to represent my committee's concerns, and a lot of those were allayed by some of the changes that this committee had already made. And so we had the final walkthrough from Ledge Council just last Friday, I believe. And the sort of the issues that were brought up around the language change that says that, and we switched it to and, is something that came up during that discussion of the final walkthrough of the bill. And it made a significant difference And so I didn't feel like it was something we could just let go. And wanted to bring it to you as soon as we sort of solidified that. It was not something that was brought up prior to that. So the things that we had brought up prior had really significantly been addressed.
Okay, thank you for that. And my last question is, in terms of the substance, and I guess the position that Human Services is taking, that individuals' disability is not the underlying or catalyst cause of the actions that they take, and it just seems to me, the hours of testimony that we've taken on this bill is that these are extremely dangerous individuals. I mean, they've been charged, not convicted, with 15 of the most serious crimes that we can possibly imagine, including terrorism and murder and kidnapping, sexual assault. I mean, I can go on and on. And I'm wondering if you have any empirical evidence to say that a person's disability is not a direct cause or contributing factor to the actions that they take.
What I have is, and I want to be clear that our committee, our committee only has jurisdiction for people with intellectual and developmental disabilities, brain injury, and older Vermonters. So, Alzheimer's or dementia. We do not have jurisdiction for people with mental health challenges, mental illness. So I can't cite for you the literature sitting right here. I can tell you, based upon my 40 years of experience in the field, that for people with developmental disabilities, and remember, that's who I'm talking about here, I can be clear that they often did not understand the actions that they were taking. And it was, that's why I have appreciation for the fact that essentially the biggest and most important chunks of Act 248 have been also included in this bill, because a person with mental illness and a person with developmental disability are not the same thing. And so that's what I can offer you.
Yeah, thank you.
You're welcome.
Thank you. I had some of the same concerns Zach did. One of my big concerns is, to me, an amendment of this magnitude coming in at past the 11th hour is unusual from what I've seen since I've been in the building. And I even look at it being a little more unusual with all the time. I know your committee didn't have possession of the bill, but I know that you spent a lot of time on it, probably as much as we have. And the same with corrections, even though they didn't have jurisdiction. And I'm going to repeat a little bit, but last week we voted on a bill in here. And I really didn't want to vote for the bill because I wasn't happy with the direction that it took. And I don't want to say I was convinced or talked into it, but I ended up voting for it and reasons to do it. And convinced other people to do it, where we ended up with a unanimous vote out of this committee. People voting for it that weren't happy with what was in it. And then, because I'm considering fully my support for the bill, because not that your amendment's terrible or anything like that, but again, the unusual nature of it being this late. I think you said you've been working on some of this language for quite a while. It's been around for a while.
Actually, just Friday is what I said. This language became apparent to us on Friday.
Okay, I thought you said you had been working on the amendment in the committee. Maybe I misunderstood you.
Correct.
Correct, you were working on it?
No, correct. You misunderstood.
Okay. But regardless, I just think it's too big a changes for me, unless somebody can talk me into something different. If your committee didn't have so much time to work on it, and come up with, I mean, you came up with the changes and, and the beliefs of your committee were already in the bill. I mean, if they were already in there, would have been one thing. But again, after the vote that we had, Zach may have brought it up, that just troubles me. But so I've been talking with somebody who has, I guess you could say, a vested interest. And they asked me to ask some questions. And I've got 5 questions I want to ask for these people. And how does the amendment maintain alignment with national forensic standards that base placement on legal status rather than diagnosis?
This does not change anything with regard to legal status of placement.
It-
The amendment does not change
Right,
anything in that
it's not the
regard.
way it usually works with forensics, so.
I'm not a forensics expert. So I'm saying that this does not change anything with regard to your committee's work,
Right,
with regard to the qualifying crimes that a person is charged with.
so that brings up another question is, who's the forensics expert in your committee that's guiding you?
We had testimony from an individual who has worked, former executive director of a designated agency who has placed and worked with these folks, Dr. Bill Ash. You can see his testimony. I also consulted with the person. She did not provide testimony, but provided me with some information and my own experience in terms of the community placement side of things. But
Right, but you said your experience isn't in forensics and this is.
no, I'm talking about the community placements. The forensics, Dr. Bob McGrath is a nationally known forensics expert, and I did not speak with him personally, but have benefited from his expertise. I'm not changing anything. Our committee is not changing anything about the crime with which a person is being charged and which makes them eligible for this facility. I just need to be clear about that.
All right. What peer-reviewed evidence supports reorganizing a forensic unit around diagnosis instead of legal competency and risk?
The forensic facility, and particularly around this area, is talking about trying to reinstate somebody's competency. If you are reinstating somebody's competency, you have to understand what their underlying condition is before you can reinstate their competency, or even attempt to reinstate their competency. And so, for instance, a person with a significant mental illness is going to have a different path towards restoration of their competency than somebody potentially with Alzheimer's, or somebody with a brain injury, or somebody with a developmental disability. You do not, if you have a developmental disability, by definition, that disability is lifelong. It's a different qualification of individuals who will be assessing that individual and making recommendations.
So I guess it kind of raises another question for me. If he is diagnosed Alzheimer's, that type of thing that you listed, but they need the forensic type treatment. That, to me, it appears it's been stripped from the bill because it's 2 different types of treatment.
No, sir, that has not been stripped from the bill.
Giving existing workforce shortages, how will the additional clinical requirements be staffed and funded?
The services for people in the community are funded through Medicaid, and some general fund as well. And the bill, as you already know, provides for up to 18 months for appropriate community placement to be secured for an individual. We did not change any of that.
How does the amendment avoid duplicating or fragmenting services already provided by mental health and developmental disability systems?
It doesn't duplicate them at all. It is actually building upon what already exists, which is the point.
And one more from the constituent, given that Vermont currently lacks a consistent placement system for individuals found incompetent to stand trial, how does the amendment address the absence of placement options rather than simply adding requirements to a system that does not yet exist?
So the constituent is, seems to be unfamiliar with the placements that already exist in our community for people with intellectual and developmental disabilities under Act 248.
Yeah, I think what they're getting at is the people with this level of crime being in a place that's safe for the public.
And if the commissioner, if there are provisions in the bill which we have not changed, I want to make that absolutely clear.
No, I didn't say you changed anything.
We have not changed the provisions under which somebody can be held in the facility. And the bill, as you passed it, provided provisions for people who are not going to be able to be restored to competency. And those are most likely going to be the people who actually are already being served under Act 248 in the community. Okay, and we actually added provisions to the feasibility report that's coming back about actually expanding Act 248 so that there would be community required placements for people who may commit a crime, who have a brain injury or who have dementia. Other people.
Crime is different than the types of crimes we're talking about here.
Well, it would include these. It would include these crimes, sir. I think that.
I'm just worried about where they are now. They don't belong in jail. They do, but they don't. But to me, they belong in a forensics facility, which this bill puts off. It gets rid of the interim facility, until we could build something. And my fear, and I don't think it's a fear, I think it's a truth. We're going to get in line behind the juvenile placement facility. We're going to get in line by the Women's Correctional Center. We're going to get in line behind which I don't agree with anyway, but the injection center in Burlington. And now we're just, all those things have been studied to death and nothing has ever been done with them. And my fear is with this bill that we're going to end up in the same spot and we're not going to end up with a forensic facility because of what the bill says. And I'm just frustrated with that we're studying something again. I don't know how many studies we've done. Maybe we're going to try to get up into the 40s like we have with our ed bill, before we do anything. And we still haven't done anything with that. So I'm done.
Can I just ask you a question, Tom? Okay. Are you talking
I don't know
about,
if I can answer it.
yeah, you can. Bill or amendment are you talking about?
Because the amendment doesn't do any of those things.
It's the bill.
The bill.
The bill.
Okay, thank you. Thank you.
Yeah, Ian.
So the one concern I have on the amendment is changing the qualifying condition and the substantial risk. So having it be both and not having them related to each other. Just on the constitutional concerns, I think my understanding is one state, New Mexico, has similar language, but the rest don't. And that law, while not being found unconstitutional, hasn't been challenged. And so I'm just wondering if you guys have any testimony about that, or if there's anything waylay my concerns.
I've not taken any testimony about that particular state's statute, no.
Okay.
Questions or just not? See, thank you very much. Really appreciate you.
Thank you very much for your consideration. And again, I appreciate your work on this bill. Thank you.
So Eric, actually, if you can join us, because I would like you to do two things. If you could just, on this version 3.1, there was the one change that, so there were, just real quickly, there were three issues that the state's attorneys had fulfilled. Two of them were taken care of in version 2.1 that Kim McManus addressed after Jared Bianchi's testimony yesterday. That was in the second and third amendment. There was the third and fourth, I mean. But there was a concern about timing and the additional petitions of individuals in the fifth instance of amendment. And talking to, again, Kim McManus to try to allay that concern. There's different language on that. So if you address that, and then if you could just address that issue that Ian just brought up as well, that would be helpful.
Sure. Eric Fitzpatrick, Office of Legislative Counsel, here to talk with the committee a little bit about the most recent version of the proposed amendment by Rep. Wood and others that was just being discussed. And as Chair indicated, I'll direct my testimony to, first of all, page 2, which is the fifth instance of amendment. And actually, this is something that probably is still highlighted on everybody's document.
Yep.
Yeah.
But just so you know, the technical matter, that depending on what happens, that's still a correction that has to be made to this document. In other words, it has to be cleaned up because it's not supposed to have highlighting in it in the final version. It's only in this version for purposes of the committee being able to see what the changes were between this version and the previous version.
Right.
It's what I usually use highlighting for. So the idea here is that if I remember correctly, there was concern being expressed with respect to this opportunity for a person who's been found not restorable and dangerous to have their status, their dangerousness status reviewed periodically by the court and after they petition to have their status reviewed. That part, subdivision 3, Romanet 3, did allow them to have their proposal amendment anyway, allowed them to have their status reviewed at any time they filed the petition. But the way it was phrased was at any time after 90 days following the order of commitment, that's when they find them dangerous and not restorable, and not earlier than 6 months after the filing of a previous petition. That was the previous language. But the problem with that, and which is the same problem that the committee addressed in another part of the bill a couple of weeks ago, you may recall this exact issue came up in a separate filing, so not related to this particular stage of the process. At a different stage where there was a 6-month review, not a 12-month, the language had been phrased that way, and I think the committee realized, well, wait a second. If they can file a new petition 6 months from the time that they filed last time, but it takes a long time for a petition to get resolved. It could easily take, like, they got to get an evaluation. They can have the opportunity to have their own evaluations done. Court hearings take time to schedule, et cetera, et cetera. All that takes time. So if they can file their petition 6 months after the last one, that could be like 30 days after the previous one gets resolved, which was not the intent of the committee. So what I did was I took the same language that you used there, which is lines 15 to 17, and said, the clock doesn't start that. It doesn't start when they filed the last one. It starts when the last one was resolved, when the court issues the order. So then there's a true 6-month gap between the time of the previous proceeding and the next. So that's the language issue there. It has to be 6 months thereafter, not earlier than 6 months. Now it's phrased from the issuance of an order for continued commitment under subdivision 4A. So in other words, it's after the court's already gone through all the evaluations, the proceedings, weighing the testimony from the parties, et cetera, issues the order, then the 6 months clock starts ticking. I think that was not, the idea was not to have these petitions be successive right after one another, but rather have a time gap in between when the person filed them.
All right, any questions on that? Now, see if you could address that other issue as far as the change from that to and.
Yes. And what's going on there, you may recall, I think it was yesterday that I walked the committee through this. But the notion there is that the proposed change in a number of different places is rather than saying that the person has a qualifying condition that makes them a substantial risk, in other words, the qualifying condition that makes them a substantial risk, instead the proposal is you have a qualifying condition and you're a substantial risk. So there's not kind of a causal connection between the condition and the risk. And, I don't have any case law that I've been able to find that addresses the constitutionality of that particular thing. So all I can tell you is that there are examples of both in Vermont and in other places nationally. For example, Representative Goodnow mentioned the New Mexico statute, which uses the structure that you had in the amendment, which is and, you're dangerous. And you have the condition and you're dangerous. On the other hand, the federal statute that Congress passed, just as another example, uses the way it's formulated in the bill now, as it came out of this committee, which is the condition that causes the danger. So you have examples of both. I haven't seen any case law that addresses that, so I think doesn't necessarily mean there isn't case law out there that I haven't found, but I haven't seen any. So I don't think there's any real guidance as to whether one is necessarily more constitutionally suspect or infirm than the other. I will say also that you also have examples of both in Vermont, in the sense that in the current criminal commitment statute, in Title 13, if you're going to be committed to jail as the result of a mental illness, that's phrased as the mental illness that causes the person to be a danger to themselves. So in other words, that's the formula that was in the bill that came out of this committee. On the other hand, if you're committed to jail when you've been found incompetent to stand trial for NGRI as a result of an intellectual disability, it's phrased this way. You have an intellectual disability and you're dangerous. So there's examples of both. And, as I've said from the very beginning about this bill, it will be litigated. Not maybe, it will be. And no matter what you do really with the language, it doesn't matter. It'll be litigated because we don't have it in Vermont right now. If you're a defense lawyer, you have to raise these questions. It would almost be, you have to raise them and to be providing effective assistance to counsel, in my view. So ultimately, the court's going to have the final word on it, no matter how you phrase it. So there's examples of both. And I guess that's all I have to say. That is enough to give you a sense of my perspective.
Ken and then Angela.
So the and adds to a potential problem or potential questions, or it doesn't, or does it make it more widespread?
No, I think I don't think either way. It's 50-50. You're going to get challenged no matter what. And I don't have, it doesn't change anything in the way that can make me say, oh, because of these other cases I read, or because of something that it makes it more vulnerable. I don't see that. I think it's the same level of vulnerability either way, it seems like.
Okay, and then this terminology, for lack of a better word, that's all throughout the bill for the most part?
Yes.
Thank you.
Yeah.
And I'm trying to just make sure I understand, is this in your mind a substantive change or a word choice?
It's a substantive change.
Okay. Yes.
Yes.
And if anything, it actually means that there are more people who could potentially qualify, not fewer, right?
I guess wouldn't say that I would be able to answer that question. I'm not sure I see that in terms of the number of people that qualify. It doesn't seem like it would necessarily be any different. But I'm not sure. It's not, I think maybe that requires some clinical knowledge that I don't really have.
Okay, then I'll just ask you if you can, I'm sure you already did this and I didn't quite get it, but can you explain how, from your perspective, how it's a substantive change?
Yes, the bill as it passed out of this committee required that a causal link between the qualifying condition and the dangerousness. This proposal does not have that causal link. You only have to prove both of them.
I guess
Rather
that's
than-
why I think it would potentially like scoop up more
I
people.
don't think it scoops up more people. I think it makes the burden of proof easier for the state's attorney. They
Okay,
don't
maybe
have to-
that's.
They don't
fine.
have to establish that causal
Yeah.
link. They just have to say, they have the condition, the qualifying condition, and they're dangerous.
Yeah,
So I think that's the main thing that it does.
I agree with that. Now that I hadn't thought of that, but I think
that's what
right.
I think that's the way to phrase what I was thinking, that it means that the burden is actually lower.
Well, it's still
In a
convincing evidence. They just have to
Yes.
do one less thing.
The
Yeah, that's what I was gonna say. The one less thing they have to prove.
the task list just dropped one task with this change.
One element of truth that.
State's attorneys have one fewer thing, one to prove. Okay.
But we do get outside of sort of the protective umbrella of federal language that we've sort of been using by making this change.
Well, yeah, in the sense that the cases, to the extent there are some, which there are, that have interpreted the federal law, might not be as relevant in an interpretation of this language because this is different than the way the federal law is set. Yes, I agree with that.
And then my only other question was for, I don't remember, does the forensic risk assessment, does that actually get into the qualified condition at all, or is it just about the risk?
I think it's risk. I think it does talk about competency.
At the very end, I guess that was like.
There's an opinion on competency, there's an opinion on restorability. If restorability is asked for. Nothing specifically about qualifying condition, but it does ask for opinions on, like you said, dangerousness, that sort of thing.
So I guess my question is, why, if we are divorcing the qualified condition from risk, why are we requiring the forensic risk assessment to be done by someone who is appropriately qualified for the qualifying condition?
Are you talking about the other amendment proposal?
Yeah, sorry, the other proposal amendment
Right.
for the
Well, you have Romanet,
the very last one.
6, for instance, examiner's opinion as to whether the person needed custody care and rehabilitation. That's going to have to be somebody who does cognitive disability or intellectual disability. And examiner's opinion is whether the person's competent to stand trial. That doesn't a particular, but I'd say number 6 definitely.
So it's enough, there's enough in that. That's why I couldn't really, so the forensic risk assessment does get into the qualified condition, at least somewhat.
At least somewhat.
Most of it seems like it's about the risk.
I would say Romanet 5 as well is it's going to take some special expertise on whether it's mental or emotional cognitive disability on what an appropriate placement would be for this individual.
Yeah, okay.
And whatever, I also answer that just by saying, I think that, again, not having clinical expertise, but whatever the qualifying condition may be from, it may be that people have different expertise on that depending on what the condition is. So maybe the evaluator might be a different person by qualification, depending on what the condition is.
Yeah, that makes sense. Great, thank you.
I do want to clarify an answer I gave to Representative Gossman, that you asked whether this was throughout the bill, referring to the and that distinction that I've been talking about. And the amendment, as has most of the recent discussion, is focused on the competency to stand trial, right? You've got another piece of the bill, which is NGRI, not guilty by reason of insanity. That still has the other structure, qualifying condition that causes dangerousness. Not that you can have it different in both places because they're two different populations. Maybe there's a reason for that, but I just point that out so that the committee knows about it. And you could say, well, we want them to be consistent. You could say, well, we prefer that We think that the NGRI population is different. They are being held after they've been found not guilty of the crime. It's different than competency when they're never found not guilty. The criminal charges are still pending. On the other hand, not guilty of original insanity, barring a statute like this, they'd have to walk in all likelihood unless they had a mental illness that made them dangerous to themselves or others. So you might say in that situation, well, we want the threshold to be higher a little bit. We want the prosecution to have to prove a little bit more. We want them to have to prove that causality. See what I'm getting at? So again, I just point that out because I realized my answer to Representative Goss's question wasn't entirely accurate, but I thought about it. So I want you to committee to know that.
But thank you, Art. Yeah. So just to try, we're getting close to the end of the session. And it could be even, I keep on hearing from the speaker that we want to be done by this weekend, but that's not happening. But we're talking about only a couple days, possibly next week, even. So I would like to try to move this along to get it to conference committee. I know that we may have an amendment that Tom wants us to consider as well. And hopefully we can, have that today and just try to get this over to the Senate for conference committee. So I'd like to start with this particular amendment from Wood. And I would take a motion to find the draft number 3.1 of the Wood et al. Amendment on S-193 favorable.
Just a quick question on that.
Yes.
Would it be will I get a new draft number once it's cleaned up?
The only reason I would say yes is because we wouldn't, if it was just to clean up the highlighting, like we don't do it,
Yes.
that's just editorial. But the other change is to add Representative Donahue as a sponsor. So given that, for purposes of having the clean paper trail, we would make that a new 4.1.
All right, so we won't vote on this one right now. And then we'll be able to look at Tom's amendment at the same time. And do you have a time? Do you have any suggested time, Tom?
No, we're gonna have to schedule Eric for a walkthrough on it. That'd be the biggest thing, I guess.
Okay.
And trying to line up a witness potentially. I don't know if that's gonna happen.
Sometime before you hope? I
Right.
just wondered. Okay.
Yeah, no,
Right.
as soon as I
So
can.
we'll take both these amendments up when we reconvene.
Well, that'll give me time to go.
That'll give you time.
We do this one real quick and then keep me posted on when you
Yeah.
come back together.
Right.
That sound good?
Yep, thank you.
I'm sure you might have something else to do.
Yeah, but I actually have some flexibility also.
Oh, okay, good.
So,
That doesn't always happen. Flexibility.